Good afternoon, ladies and gentlemen. It's fantastic to see so many young and enthusiastic inventors in the audience today. My name is Hunter Parks, and it's an honour to be presenting at this intellectual property seminar. I'm going to be giving you all a very short and brief explanation of an integral aspect of intellectual property, and that is in relation to the topic of patentability. Specifically, I'm going to address the Patent Cooperation Treaty of 1970 and elaborate on exactly the basics of that treaty, what it is, and how it operates in practice. So the Patent Cooperation Treaty simply offers patent protection for inventions in over 152 nations around the world by filing just one patent application. Filing this application is a very important part of the process for inventors seeking international protection of their inventions and international property. Inventors are able to file an application with one or more of the contracting states of the treaty, and what this means is that if you receive approval of your application, you can seek protection in several countries simultaneously. The treaty is a multinational agreement and it dates back to 1970. It is also administered by the World Intellectual Property Organization. In practice, the treaty operates predominantly through this application process, and the granting of patents remains under the control of the national or regional patent office. The international patent application process is primarily used for inventors contemplating expanding or seeking to exploit their business internationally. The application system is designed to be efficient and informative, and it does streamline the process of fulfilling those diverse formality requirements, as well as postponing major costs associated with international protection. Many of the world's major corporations, research institutions, and universities utilize this treaty and their application process. The international application is subjected to an international search conducted by a component of the international searching authorities. The ISA will generate a report that lists citations of published documents that may affect the patentability of your invention. This report contains indications of each document listed as to their possible relevance to the critical questions of patentability. These questions are known to be questions of novelty and questions of inventive steps. The report enables an applicant to evaluate their chances of obtaining a patent in those contracting states to which they seek. For example, if a search is favourable in that the documents cited do not appear to prevent the granting of a patent, this will assist the applicant in further processing their application. On the other hand, if a search is unfavourable insofar as the documents challenge those questions of novelty or inventive steps, the applicant is afforded up to 18 months to reflect on the desirability of seeking protection, and this means that they can amend, refile, or withdraw their application. So it is a very cost-effective and useful process for inventors. Additionally, for every international application, the ISA will also establish a preliminary and non-binding written opinion on whether the invention appears to meet the patentability criteria in light of those search results. The purpose of this written opinion is just to further assist in interpreting the results of those research reports. An application may be filed by a national or resident of those contracting states to the treaty, and if there is a group of members responsible for one invention, then one member only needs to meet this criteria. Thank you for your attention today. I hope I have informed you a little bit more about the Patent Cooperation Treaty of 1970.